Hui-Litwin, and today we're going to continue our conversation on financial disclosure in family law proceedings in Ontario, Canada. If you're new here, don't forget to check out our series of videos that we've already done on this topic by clicking on the link in the description box below. So before we begin, I'd like to remind everyone that these videos are intended to be general legal information, and for advice specific to your case, please consult a lawyer. So joining me here once again is lawyer Shmuel Stern of Disclosure Clinic. Hi, Shmuel, welcome back.
Hey, Heather, how are you?
Great, yes, Shmuel, so you mentioned the other day that you wanted to share with viewers when to disclose what information. Am I correct?
That's correct. I actually think of all the videos that we have done, this is probably the most important one.
No.
Yeah. And the impetus of this video is that there was a recent rule change buried into Rule 20.2 of the family law rules, which who would know what, not even the lawyers knew.
Oh my goodness.
That says that if you don't provide something by a certain time,
yes,
there's going to be a punitive action against you and or consequence. And who's to know? Who's to know this? And where's the education to understand what you're supposed to do as opposed to what you're not supposed to do? So on my website, I have a series of posters and infographics.
Right.
And one of them, so I just posted this one called Advancing Your Disclosure Through the Court Process. And I feel like that is so necessary to know what your responsibilities are, because it's very easy in a family court proceeding to get caught up on the parenting issues.
Right.
Understandably so. And also to get caught up on the other party's disclosure, that you kind of miss the point of your disclosure, and you don't want to get to in front of a judge. And this happens a lot, where the judge looks at each of you and says, okay, have you done your responsibilities? Have you done your responsibilities? And you are coming up empty-handed, and it affects your case, right? Both on what you are looking for and what you're defending against. So this particular poster, if you see, the motif is chess pieces.
Yeah.
And the reason was I needed to come up with some metaphor for the fact that you need to think in the future. What you're doing today should be thinking in the future. And what I do at Disclosure Clinic is think at when a client comes to me, I'm looking at the very end and I'm working backward. As opposed to working forward. And forward is important also, but you don't want to get to trial, which is the very last step here, and have a judge say, you have an interesting and valid claim, but you don't have the paper to support it. And then you're like, well, nobody told me. So I spent all this time and money to get to this point, and you can't give me what I want because I don't have the paper. If I knew to get the paper, I would have provided the paper. So that's why this is important, is to think, to have a little bit of to imagine somebody going through a court proceeding, having much brain space other than what's immediately in front of you, but to think into the future. So that's what we're going to do today, is go through this step by step with a demonstration of specifically what's needed.
Can I just ask a quick question? So can't you just ask the judge, I didn't realize you need that. Can we adjourn the trial and let me go get it? That doesn't happen? You're not allowed to do that?
That can happen. It's rare to happen. In other words, the judge is not going to be telling you necessarily. It really depends on the nature of the issue and which side of the issue you sit on. I'll give you a very easy example. Okay, let's say you're a support payor. Okay, you're paying so that's not so that's clear. And you receive bonuses.
Okay.
and you don't want to pay child support, let's say, based on your income with the bonus, because you don't know whether you're going to receive the bonus or not.
Right.
Okay, a judge is not going to tell you what to do to prove that claim, and it is a claim. There is law on whether or not to include a bonus in ongoing support. Okay,
Mhm.
and when I say included, I mean it will be included in your income, but maybe it should be included only after you receive it, as opposed to before you receive it,
Mhm.
right?
Mhm.
On speculation. So there is law, there is paper to support the law. Very briefly, you would want to at least show the court in the years past whether or not you've received it. It's much more compelling to say, look, Your Honor, 3 years ago I did receive it. 2 years ago I did not. 1 year ago I did not. Last year I did. I don't want to do it this year because I just don't know. You see how it's not consistent. Okay, but no one's telling you to prove that. And if you just show up with your tax returns or your notice of assessment, it doesn't show the
Mm.
components of bonus versus not bonus. It doesn't show when you received the bonus in the year, like within the year.
Yeah.
So there's information to be provided, but if you don't know to provide it, a judge is not going to tell you, and the judge will just say, "Well, you didn't provide me the information, so I can't help you." So
Wow.
that's just that's an example.
Mhm.
Okay.
Mhm.
So let's just move through this. As you can see, there are 6 steps here.
Mhm.
Not all are equal. Not all are built the same. You're going to get Most people get very stuck between the case conference and the settlement conference.
Mhm.
Okay. And the other thing I would just want to say before we begin is that even if you're not in a court case, the buildup of your disclosure is similar. So even if you're outside of a court process, the process that you're going to be using in order to advance the issues in your separation are similar, just not with the same kind of timelines that are built into a court process.
Mm.
Okay, so
Okay.
let's get going. So the step number one, remember there are 6 steps. So step number one, most people are confronted with a financial statement. Okay, now a financial statement is information. If you think about it, you're just filling in information. And with that information, you have to provide some documents. And those documents are as follows. You're supposed to attach proof of your current income. So, for example, a pay stub,
Mhm.
or EI, employment insurance, some form of stub of that. Just a proof of your income, of what you're receiving if you're employed. If you're self-employed, there's also a statement of income and expenses. These are all on page 2 of your financial statement, where it says attach the following. So proof of your income and notices of assessment for the past 3 years.
Right.
Okay, most people kind of get that.
Mhm.
And this is like very bare bones disclosure. As a lawyer, I could tell you the notice of assessment tells me very little. Okay. But we're not talking about that. We're just focusing more on the levels of disclosure that we're going through. And it's written very confusingly on the same page 2 of the financial statement, but you're also supposed to serve, to provide
Mhm.
tax returns for the past 3 years. You're not supposed to attach it to your financial statement, but you're supposed to provide them. Okay, so that freeze frame, that is the bottom floor of financial disclosure in family law.
Right.
And you would be surprised, or perhaps you would not, that asking for tax returns, sometimes we have to wait till step 3 or 4 to get even basic tax returns or complete tax returns. And you, as a person going through this process, want to create a solid foundation for your disclosure that's to come. Okay,
Mhm.
because again, this is not where the action is. The action is going to come at the case conference, between the case conference and the settlement conference.
Mhm.
So here we are, financial statement, basic documents, and move forward. Okay. Now the law says, and when I say the law, I'm referring to Rule 13 of the Family Law Rules, okay, which deals with financial disclosure. However, not all of the financial disclosure information that I'm going to provide you is in Rule 13, which is where it gets confusing. So 30 days after you serve your financial statement, you are supposed to provide the rest of your documents, of the basic documents. So what does that mean? It means for your income documents, you need to provide what is required under the child support guidelines. Okay, and in Disclosure Clinic, and I'm leaving up the URL here, there is a checklist, and I'm going to show it to you. See, it looks like this. I think I can open it. There you go. And it's a checklist. Let's see if I can just make it a little bigger. Okay. So again, you should have already provided your tax return information for the last 3 years. Okay. And if you're an employee, you should provide a recent pay stub. That's already in the financial statement. We've already gone there. Okay. And then there's more stuff for self-employed. You have to provide your corporate financial statements. If you have a subsidiary, again, much of this may already be in your personal tax return if you don't have corporate, but there are other ancillary income documents for people who have more complicated income. So if you have a trust, if you're self-employed, you may have non-arm's length transactions that you have to disclose that nobody thinks about. So I created this checklist of whether you have non-arm's length. And then lastly, and importantly, because really this should also be included in your financial statement, but it's difficult to get this type of paper. But if you're seeking sharing of child expenses under Section 7 of the Child Support Guidelines, you need to provide evidence of the documents. Of the expense, documents of the expense. So if you have a daycare expense, then there should be some form of evidence of the daycare expense. And if there's any subsidy, benefit, or tax deduction, then that too should be disclosed. Again, if you look at Schedule B or C, depending on which financial statement you're using, there is a schedule that tells you to do this. Many people don't do it, but within 30 days, you should get your act together. If you're asking for the other party to provide money towards a Section 7 expense, you should be providing evidence of the Section 7 expense. Okay. So that's that you need to provide within 30 days. And then there's property documents. And this is where the heavy lifting of work really happens. And I haven't made a checklist for this yet. It's on my to-do list. But Rule 13, 3.3, and I'm going to click on it. So it's the family law rules. So 3.3, it says, here's the additional financial disclosure that's required. And it kind of lines up with the financial statement for a 13.1 financial statement. So if you're seeking an equalization of net family property because you're married and separated, then you need to provide documents for each entry that you have as a valuation date, asset or debt, or a date of marriage, asset or debt. And so let's just go for a few examples of this list. And this is right out of the rule. The statement issued closest to the valuation date for each bank account or other account in a financial institution, pension, registered retirement, or other savings plan, and any other savings or investments in which the party had an interest on that date. Okay, English, you need to provide some piece of paper that shows that if you're claiming there's $300 in your bank account on your date of separation, that it actually existed at $300. Now, the rule doesn't say how to provide it, right? Just that you're supposed to provide it. So many lawyers and their law clerks will compile a brief, and I'll show you a brief later at the end of this, towards the end of this program, of what a brief could look like. But you're basically collecting the proof as if you're going through an audit of your financial statement of those two columns, valuation date and date of marriage. Okay. Now, if you have, if your situation is a little bit more complicated, if you have corporations, for example, then it also asks you for corporate information that's slightly different than what I showed you on the checklist for income. And if you are seeking to exclude property, then that should be provided also. Um,
Mm,
Many people will put stuff on their financial statements saying, just believe me, this is what I'm telling you, and you will not be believed because you're in an adversarial process. So you need to prove what you are saying in the financial statement, and that is supposed to be done within 30 days after you serve your financial statement. Now, if you're thinking ahead, okay, when you're doing your financial statement and when you're collecting the data to put into your financial uh, statement, you should be collecting the documents at that time.
of course.
That's already thinking ahead,
Yeah.
right?
Yeah.
Okay, so that's like one step ahead, that you are thinking ahead, that while you're filling out the form, you are also collecting the documents. We have videos that we've done in early days on setting up folders on your computer or on your cloud storage to start collecting that documents, like to get ahead of this timeline,
Mhm.
right?
Mhm.
Doing so will benefit you greatly because you're not going to get the letter that says, "Oh, you haven't complied with the rule." Right? That letter will come,
Yeah.
and you don't want a court order that says that you haven't complied with the rule. Okay, so that is step number 2, which is the balance of the income documents and the balance of the property documents, which are supposed to be provided 30 days after serving your financial statement.